Bills pour le reading of the loi troisième lecture. Number 1, Bill S-13.
Stand.
Numéro 2, C-21.
Senator Carignan.
Senator Carignan. Thank you, Madam Speaker. Dear colleagues, I rise today to speak to Bill C-21, an act to amend the Firearms Act and certain other acts. As had already been highlighted, there are very few elements of the bill in its current form that deal with the reality of gun crime as it occurs in Canada today. The title that the government gave its press materials last year in describing Bill C-21 is as follows: a comprehensive strategy to combat gun violence and strengthen Canada's gun laws. End of quote. Colleagues, that's how the government refers to Bill C-21. Yet, when we study the text, we see that there is virtually nothing in its measures to crack down on gun crime. In Bill C-21, the government claims that by increasing the maximum sentence for firearms trafficking from 10 to 14 years, it is trying to address the low sentences often handed down by our courts. However, the data tells us that the courts don't even impose the current 10-year maximum sentence. In fact, virtually no firearms trafficking cases receive the most severe sentencing options. Last year, in his testimony to the House of Commons Committee on this bill, retired Detective Sergeant André Gélina of the Montreal Police Services said, and I quote, "It is also proposed that the maximum sentence for individuals convicted of firearms trafficking be increased from 10 to 14 years. While at first glance this may seem laudable, no accused has ever received the current maximum sentence of 10 years for this offense. This measure will have no real effect. It's another fine example of a measure that will be ineffective." End of quote. When Mr. Gélina appeared before our Standing Senate Committee on National Security and Defense, he again expressed the frustrations of police officers in this regard. These frustrations are shared by victims of crime and other police officers, not only retired police officers, but also chiefs and deputy chiefs of police who appeared before us. As an example, Vancouver Police Deputy Chief Fiona Wilson told our committee, and I quote, "With the exception of domestic violence and police shootings, where police officers are the victims, legitimate gun owners are generally not the perpetrators of shootings in the city of Vancouver. Without exception, these firearms do not belong to legitimate owners in the first place." End of quote. Furthermore, with regard to gun violence in Vancouver over the past year, Deputy Police Chief Wilson stated, and I quote, "To date in 2023, we've had 22 shooting incidents in Vancouver that have resulted in 3 deaths and 16 injuries. 15 of these 21 incidents are gang-related or are suspected of being gang-related." End of quote. Deputy Chief Bill 40 of the Canadian Association of Chiefs of Police appeared before our committee and mentioned the following: "It's important for our citizens to remember that in Canada, gun ownership is not a right but a privilege. The law must strike an appropriate balance between the rights of the accused and those of victims, survivors, communities, and police and public safety to help mitigate the impact of the worst consequences of firearms." End of quote. Then Police Chief 40 of the Canadian Association of Chiefs of Police recommended, during his testimony, that sentencing judges be given the discretionary ability to increase parole ineligibility to 2/3 of a custodial sentence, where the court finds that an offender discharged a firearm in a place of assembly during the commission of the offense, and that this discretionary sentencing ability be extended to those found to be parties to such offences. Honourable colleagues, the punishment for the offence of using a firearm in a public place must have teeth. It must produce results. And that's what so many police officers have been asking for. Every time we propose measures to strengthen the law, to incorporate mandatory minimum sentences for serious crimes, the government comes out with its argument, questioning the constitutionality of these measures. In committee, for example, Senator Cardozo made such comments when he asserted that mandatory minimum sentences required the use of the notwithstanding clause. But this broad assertion is simply inaccurate. In R.V. Lloyd, the Supreme Court of Canada stated, and I quote, "The legislator has no constitutional obligation to provide an exception to the application of a mandatory minimum sentence. Whether Parliament should provide a mechanism for overriding the imposition of a mandatory minimum sentence, and if so, what form that mechanism should take, is a matter of public policy and within the exclusive authority of Parliament." End of quote. The Supreme Court has confirmed this position in subsequent rulings. Earlier this year, the court upheld the 4-year mandatory minimum sentence for robbery with an unrestricted firearm. Indeed, in R.V. Hilbach, the court concluded, and I quote from the majority opinion, "The mandatory minimum sentence of 4 years for use of a non-restricted firearm in a robbery does not shock the conscience and is not so excessive as to offend standards of decency. Although the sentence is severe, the high threshold of gross disproportion is not reached." End of quote. Unfortunately, as a result of Bill C-5, which received royal assent on November 17, 2022, the government repealed this mandatory 4-year sentence for the use of a non-restricted firearm in a robbery. 2 months later, the court upheld the constitutionality of this sentence. Why didn't the government then try to reintroduce this penalty into the criminal code if it truly intended to better protect Canadians from gun crime? One wonders whether the government has read R.V. Hilbach. The court concluded that this inherently dangerous offence terrorizes victims and is committed only by offenders who make the conscious choice to use a firearm to rob and endanger the safety of others.
The government is therefore defying common sense and jurisprudence by refusing to impose severe penalties for serious gun crimes, even though jurisprudence gives it considerable leeway. This brings me to an amendment I would like to propose today, which was first put to us in committee by the Canadian Association of Chiefs of Police. The amendment would create an additional provision in the law whereby death resulting from the discharge of a firearm in a place of assembly would be automatically considered first-degree murder under subsection 231(4) of the Criminal Code. Not only is the criminal use of firearms increasingly common in urban areas, but firearms are also sometimes discharged in public places with little or no regard for the impact on innocent bystanders. On Monday, November 27th, at the same time as the National Security, Defence and Veterans Affairs Committee was hearing witnesses on Bill C-21, a shooting broke out in Gatineau in broad daylight in a public parking lot. In a video captured by a surveillance camera, a person in the parking lot can be seen holding out their arm as if he had a gun in his hand and pointing in the direction of a moving vehicle. The scene is immediately followed by 2 bursts of gunshot-like noise. A few yards away, children can be seen walking on the sidewalk. According to authorities, the shooting took place around 4:45 p.m. near Eddy Street. 2 men were wounded in the shooting. And this happened while we were studying C-21 in committee regarding discharge of a firearm in a public place. We have also seen many shootings, particularly in cities like Toronto and Montreal, where innocent bystanders have been killed or injured when gang members opened fire on their rivals without regard for the consequences. In my opinion, the government must act firmly to counter the sense of impunity these criminals feel, as expressed by Chief Inspector David Bertrand of the Montreal Municipal Police Service in his testimony to the Senate Committee on C-5. He said, "What we want to work on is the perception that mandatory sentences are maintained. We want to work on the criminal's sense of impunity on two levels. The feeling of impunity is the certainty of being caught when you commit a crime and the certainty of suffering the consequences. Such reckless acts with firearms, especially when they cause death, should carry the harshest penalties, but often do not." End of quote. Take the case of Christopher Husbands, who opened fire in the food court of Toronto's Eaton Centre in 2012. He was originally convicted only of second-degree murder for this shooting, which killed 2 people and injured several others. He was originally sentenced to life imprisonment with no possibility of parole for 30 years. However, on appeal, he was granted a new trial and this time was convicted only of manslaughter. Although Christopher Husbands was resentenced to life imprisonment for manslaughter, the parole eligibility period was extended to 30 years. The eligibility period required for a manslaughter conviction made him eligible for early parole in 2021, which was only 9 years after the commission of his heinous crime. For the victims' families, this is simply abhorrent. I therefore wish to present an amendment as recommended by the Canadian Association of Chiefs of Police, which would ensure that any death resulting from a shooting in a public place would be considered first-degree murder. I think that it takes into account the reality that there are people who discharge their firearms very recklessly and carelessly. I therefore move that Bill C-21 not now be read a third time, but that it be amended on page 28 by adding, after line 24, the following. 13.01, Section 231 of the Act is amended by adding the following after subsection 6.2. 6.3, irrespective of whether a murder is planned and deliberate on the part of a person, murder is murder in the first degree when the death is caused by that person's discharge of a firearm at or into a public place as defined in Section 150. Thank you, Madam Speaker.
In amendment, it was moved by the Honourable Senator Carignan, seconded by the Honourable Senator Poirier, that Bill C-21 be not now read a third time, but that it be amended on page 28 by adding the following after line 20. Shall I dispense? On debate? Questions? Senator Carignan, acceptez-vous?
Senator Carignan, would you accept a question? You have 2 minutes remaining. Madam Speaker, I'm losing my voice, so I would prefer to save it. On debate.
Senator Lankin.
Yes, I'm entering on debate because I appreciate the voice condition you have, and I did have questions, and maybe somebody else who has worked with you on this might be able to, in speaking to this bill, respond to them. Of course, we've just heard this amendment, and I'm just reading it here. I need to put it in the context of the rest of the bill. But I want to understand the full... Yeah?
Could you move your sheet of paper from the mic? Thank you.
I can do that. Thank you. I want to ask the full impact of this amendment. I know from talking to some of your colleagues that they're in response to my questions about what some of the concerns are from your caucus about the bill. There were concerns about whether minimum sentences, for example, should be introduced into this, and a range of other things. This is slightly different. This is about what category of charge would be appropriate given the circumstances of the commission of the crime that you're talking about. And it's a very, despicable set of conditions that you have described, and so I understand why you are trying to address that. What I don't know is what at the current time within the criminal code, what discretion is there for the prosecutors or the attorneys in there on behalf of justice to give thought and discretion to what the conditions were and the person, all the sorts of things that we think about when we think about discretion of judges in terms of sentencing. And so as people talk to this, that's one of the concerns that I would be interested in. I would want to know that people who were involved in committee through all of this process have taken a look at it and have understood. I don't know if it was introduced in committee or if this is brand new. But my concern is that prosecutors have a certain discretion along with the police about what charge is laid in certain cases. And I don't know if this limits them, and I don't know if it's been looked at what the problems or consequences of that would be. It sounds reasonable. It sounds reasonable, but I need to know that. And therefore, what that means with respect to any current provision of minimum sentencing that might apply to this category of offense. So I'm hoping that others who have worked with you or talked with you and who are in opposition to this bill would speak to that when they speak to your amendment. And I'm sorry that your voice is not allowing you to answer that directly.
On debate, Senator Yussuff.
Thank you, Madam Speaker. And let me start by thanking Senator Carignan for his remarks and his work on the committee on Bill C-21. First, I'd like to say that, of course, I don't support the amendment, and I would ask colleagues to reject it, but maybe I could help answer some of the questions that Senator Lankin just raised in regards to the amendment. Section 231 of the Criminal Code, which this amendment looks to alter, deals with classification of murder. 6 sections of the code deal with sentencing rules wronging first-degree murder and second-degree murder. It defines first-degree murder as being planned and deliberate, and second-degree murder as being an inverse murder which is not planned nor deliberate. It is important, honourable Senator colleagues, to note that anyone who commits murder, regardless of the degree of guilt of an indictable offence, will be sentenced to the same sentence, life imprisonment. The difference in sentencing between first-degree and second-degree murder is simply the degree of judicial discretion. Persons convicted of first-degree murder are sentenced to life and are eligible for parole for a maximum of 25 years. Persons convicted of second-degree murder are ineligible for parole for a period anywhere between 10 to 25 years set by the sentencing judge. A judge who has heard all the related testimony in a specific case and can make a learned judgment whether to set an offender's parole ineligibility based on the facts of the case. This amendment looks to amend the sentencing rules governing murder and will provide that any murder that occurs in a public place be treated as a first-degree murder, regardless if the murder was planned or undeliberate. It will, in effect, take away the discretion of trial judge who have the best sense of the facts and the clearest sense on appropriate punishment. Honourable colleagues, it is important to remember that those who commit murder, regardless of the degree, are sentenced to life. It should be noted that this amendment looks to create a new subclass to Section 231 of the Criminal Code, one that not envisioned by its drafters. This amendment will result in some murders committed with a firearm to be treated more seriously than others. For instance, second-degree murders that are committed in a home and involve a firearm will be treated less seriously than second-degree murder that is committed in a public place with a firearm. Additionally, colleagues, Section 231 of the Criminal Code already provides numerous examples of when a murder must be considered a first-degree murder, regardless of it being intended or planned. These exceptions will always cause a murder to be treated as a first-degree murder. Example, a contract murder, murder of a peace officer, hijacking, sexual assault or kidnapping, criminal harassment, terrorism activity, intimidated, and in the murder is caused for the benefit or at the discretion or in association with a criminal organization. These exceptions to the test as whether a murder is planned or deliberate are targeted to ensure that those people who commit the most heinous of offences face the harshest sentence in the Canadian criminal justice system. The amendment that we have before us today is too broad, ignores that exceptions that are already included in the criminal code, and looks to take away the discretion once again from judges. I'd want to know why such an amendment is needed and what legal implication would be. Additionally, C-21 also includes numerous and other provisions that will strengthen existing criminal code provisions and provide police with new wiretapping authorization. This change will enable police to investigate firearms crime more effectively, including its links to organized crime. These changes are common sense and respond to the calls for reform from provincial partners. Importantly, C-21 also increased the maximum penalty for 5 different firearm offences to 14 years, including offence that target firearms traffickers and smuggling. This is an important change, though it has been one that certain senators have criticized. In fact, however, the Supreme Court of Canada has recognized that when Parliament chooses to increase maximum penalty for existing offence, is also be taken as a signal to the courts that such offence should be taken more seriously, including by increasing the sentences range for persons convicted of these offences. Bill C-21 sends an unequivocal message that firearms trafficking and smuggling can be of utmost seriousness and should be treated accordingly by the courts. Those who have criticized these changes and those who believe in a so-called tough-on-crime response would have the public believe that the only way to forcefully respond to serious offending is through exactment of mandatory minimum penalties. This is false, and as a perspective, I strongly disagree. In saying this, I should not take to saying that mandatory minimum penalties are always inappropriate or that there is no place for such sentencing tools in criminal law. They can play a role in certain cases and can send a strong denunciatory message. I believe the government understands that as the sentencing reform included in Bill C-5, which this chamber not so long ago passed, that mandatory minimum penalties remain in place, including for firearms-related offences that involve organized crime. For example, at the same time, the government's recent sentencing reform recognized that there's more than one way to address serious crime. Bill C-21 and its proposed increase of maximum penalties is evident of that. In my view, those who advocate for mandatory minimum penalties are the only response of a serious crime, overly simplify the matters and give false sense of security. Being tough on crimes means being smart on crime, and mandatory minimum penalties applied to these offences can be committed by various ways involving circumstance of varying seriousness. Are not smart on crime, and they can certainly not be tough on crime if they lead to litigation that result in them being struck down. Lengthy litigation delays justice for victims can cause them to lose confidence in the criminal justice system. Senators, in conclusion, we owe to the victims and indeed to all Canadians to be mindful of this when we consider the criminal justice policy. I say again that this amendment that we have before us today is too broad, ignores the exception that are already included in the criminal code, look to once again take away from the discretion of judges in our legal system. I urge you, honourable senators, of course, to reject the amendment and, of course, pass C-21. Thank you.
On debate, Senator Cotter.
Thank you, Madam Speaker. I had not intended to intervene in the debate.
Your mic, just a second. Okay.
Nobody cares about that first sentence, I don't think. I hadn't intended to intervene in the debate, and I have immense respect for Senator Carignan's thoughtfulness in relation to matters related to the criminal law, but I do want to raise 2 observations. One is, if the nature of this is to try to increase the mandatory minimum for certain quite serious crimes, it seems a bit unusual to do it by ratcheting up the nature of the offence, and particularly when one does that with respect to first-degree murder. The second point is a more general one, and here maybe in a slightly protective way related to the role and responsibilities of the Legal and Constitutional Affairs Committee of the Senate. We constantly face challenges at that committee. I don't want to use the word tinkering with the criminal code, but making individualized adjustments. It's a big enough challenge as it is to be comfortable that we are addressing those questions in an organized, logical, and coherent way. With respect to first-degree murder, the regime for essentially borrowing the concept of planned and deliberate, setting that aside and holding first-degree murder together for other types of offenses, particularly based on the victim, is a very fragile and carefully thought together framework. I don't even call it a regime, but a framework. And with the greatest respect, this is a problematic way of making amendments to and expanding the scope of first-degree murder without reflecting on that larger category. And as I think you will know, the Legal and Constitutional Affairs Committee was not mandated to work on this bill, and this is a matter, I think, that if it deserves consideration, it should be done independently and with a richer degree of thought. Thank you very much.
On debate or a question? Sorry.
A question.
A question. Senator Cotter, will you take a question?
Of course.
Thank you, Senator Cotter. I was reminded, as Senator Carignan was speaking, and as I read the amendment, of the Martineau decision in 1990, which I remember because I, many years later, covered a case in which a judge, forgetting that Martineau had struck a section out of the criminal code, attempted to convict somebody of second-degree murder with robbery being the predicate felony. And I'm wondering, since you are a constitutional law professor and I am not, if you could tell me whether you think that the court's reasoning in Martineau would perhaps render this amendment unconstitutional, because Martineau found that a person charged with murder must have formed the intent to commit that crime. And in this instance, this amendment, even if you didn't have the intent of committing first-degree murder, you would potentially be captured. And I'm wondering if you think the argumentation in Martineau would flow to be mirrored in this.
Speaking for myself, I think I'd need to think about that question a little bit more deeply. But what happens in the criminal code right now is that what is normally thought of as the requirement for somebody's life taken on the basis of a planned and deliberate performance by the accused person is circumvented in the language of the criminal code for a specific set of offenses, and nearly always focused on particular victims. Whether this one would fit comfortably within that regime or would be challenged, my guess is the kind of thing that would be challenged, raises, I think, uncertainty about it. And I think there's a really good argument to say that if you want to think about this as a category of first-degree murder, you need to think about the whole of those provisions that deal with first-degree murder and that circumvent the planned and deliberate requirement. And with the greatest respect, I don't think that's been explored well enough. It hasn't been explored in this chamber well enough, I think, for us to move forward. And first-degree murder is people commit terrible acts. First-degree murder is one of the mechanisms by which we hold them most severely accountable, and that's perfect and legitimate, but we have to be satisfied that we put that in place for the right types of offenses, and I think it's premature to say that this is one. Thank you.
Are senators ready for the question? En amendement, il est proposé par l'honorable.
In amendment, it is moved by the Honourable Senator Carignan that Bill C-21 be not now read a third time. May dispense.
Is it your pleasure, honourable senators, to adopt the motion? No. All those in favour, please say yea. Yea. All those against, nay. Nay. I do believe the nays have it. Two senators rising. Do we have an agreement on a bill?
Defer the vote to the next sitting of the Senate.
Defer the vote to the next sitting of the Senate. So pursuant to Rule 910, the vote is deferred to 5:30 p.m. on the next day the Senate sits, with the bells to ring at 5:15 p.m.
La question est la suivante.
The question is as follows. It was moved by the Honourable Senator Carignan, PC, seconded by the Honourable Senator Poirier, that Bill C-21 be not now read a third time, but that it be amended on page 28. May I dispense?
Que tous ceux
All those in favour of the motion will please rise.
The Honourable Senator Plett. L'Honorable Sénateur Carignan, CP. The Honourable Senator Martin. The Honourable Senator Houssakos. The Honourable Senator MacDonald. L'Honorable Sénateur Mockler. L'Honorable Sénatrice Poirier. The Honourable Senator Seidman. L'Honorable Sénateur Boisvenu. The Honourable Senator Marshall. The Honourable Senator Atuljan. The Honourable Senator Wells. The Honourable Senator O. The Honourable Senator Batters. L'Honorable Sénateur Dagenet.
All those opposed to the motion, please rise.
The Honourable Senator Gold, PC. The Honourable Senator Harder, PC. L'Honorable Sénatrice Bellemare. The Honourable Senator Francis. L'Honorable Sénateur Massicotte. The Honourable Senator Jaffer. The Honourable Senator Lankin, PC. The Honourable Senator Laboucan-Benson. L'Honorable Sénatrice Moncion. L'Honorable Sénatrice Dupuis. The Honourable Senator Pate. The Honourable Senator Patterson, Ontario. L'Honorable Sénatrice Werner, CP. The Honourable Senator Cordy. L'Honorable Sénateur Dalphon. The Honourable Senator Anderson. The Honourable Senator Klein. L'Honorable Sénateur Gignac. L'Honorable Sénatrice Méville-Deschênes. L'Honorable Sénateur Cormier. C'est qui? Galvez. The Honourable Senator Moody. The Honourable Senator Duncan. The Honourable Senator Sorensen. The Honourable Senator Deacon, Nova Scotia. The Honourable Senator Osler. The Honourable Senator Bury. The Honourable Senator Bernard. The Honourable Senator White. L'Honorable Sénatrice Gerba. The Honourable Senator Cardozo. L'Honorable Sénateur Forêt. The Honourable Senator Petten. The Honourable Senator Beam. The Honourable Senator Kutcher. The Honourable Senator Yussuff. The Honourable Senator Quinn. The Honourable Senator Prosper. The Honourable Senator Black. The Honourable Senator Down. L'honorable sénatrice Ringuette. L'honorable sénatrice Petitclerc. L'honorable sénatrice Saint-Germain. L'honorable sénatrice Clément. The Honorable Senator Umivar. L'honorable sénatrice Moody. Meji. The Honorable Senator Hartling. The Honorable Senator Cotter. The Honorable Senator Wu. The Honorable Senator Harnott. L'Honorable Senator Lufreda. The Honorable Senator Coyle. The Honorable Senator Dasco. The Honorable Senator Ross. The Honorable Senator Kuzner. L'Honorable Senator Aucoin. The Honorable Senator Simons. The Honorable Senator Boyer. The Honorable Senator Dean. The Honorable Senator Boniface. The Honorable Senator Rabalia. The Honorable Senator Greenwood. The Honorable Senator Bussin. The Honorable Senator Deacon, Ontario. The Honorable Senator Kingston. The Honorable Senator McNair.
All those who wish to abstain, please rise.
The Honorable Senator Smith. The Honorable Senator Wallin. The Honorable Senator Richards.
Yeas pour 15, nays Cont'd 66, 66, abstentions, 3-3.
En conséquence, la motion.
Therefore, the motion is defeated. Resuming debate on C-21.
Senator Plett.
Well, colleagues, I don't think I'll be able to speak fast enough to beat the bell on this one, so we may have to do this in 2 shifts. But I rise today to speak on Bill C-21, an act to amend the Firearms Act and certain other acts. Colleagues, we have seen many bills pass through this chamber in the past 8 years. And if I am being charitable, I think it is fair to say that a significant number of these bills have been beset by challenges. Some reflect a tendency we have seen in the current government to not think things through. Too often, such bills have not put the interests of all Canadians first. These bills have been highly political. In this regard, we are all familiar with bills like C-18, the Online News Act, which will come into force in just a few days. This bill is living up to all the shortcomings that witnesses who appeared before committee warned us about. Then, of course, we have had the range of criminal justice bills that the government has enacted, all of which were driven by an ideological soft-on-crime approach. Bills like C-5, C-75, and C-83, and they have contributed to the significant spike in crime, including violent crime, that we are seeing across Canada. These bills have not only failed to achieve their declared objective of enhancing public safety, they have actually undermined the ability of our police force and corrections officers to combat the control rising violent crime. And now we have Bill C-21. This bill is certainly one of the most divisive bills that the current government has ever imposed on Canadians. Like the other bills that I mentioned, the former minister claimed that Bill C-21 will contribute to the eradication of gun crime in Canada. To be sure, this is a bold claim, Senators, but it is a claim that the majority of witnesses who appeared before the Senate National Security and Defense Committee have already rejected. That is because this bill actually doesn't deal with gun crime at all. In fact, it completely ignores most gun crime. Instead, the bill targets legal firearms owners, individuals who in fact have always abided by the law. And in my remarks today, I want to discuss several issues related to this bill. First, I will discuss the total lack of consultation that the government has engaged in on this bill. This is the factor which I believe has contributed significantly to making this such a bad bill. Second, I will discuss what is a major focus in the bill, the purposed ban on the purchase and sale of legal handguns. I think it is clear that this measure will do nothing to reduce gun crime. Instead, it will only succeed in destroying competitive shooting sports in Canada for absolutely no benefit. And third, I want to discuss the expanded definition of prohibited firearms that is found in this bill. This is a measure that accomplishes nothing in the short term, but I think it reflects the government's long-term intention to do through regulation what it could not accomplish through legislation. These three issues lie at the heart of why this is an inherently bad and divisive bill for Canada. But if we are going to be honest, colleagues, I think we need to accept that this government actually intended this bill to be divisive. That is because they view this bill as a wedge for the Liberal Party in the next election. What they plan to do is use superficial messaging to sell this bill to people in urban Canada who will not fully understand what the legislation actually does and who the government hopes will buy the simplistic message that they are eradicating gun crime. But I do not believe they will be successful in this regard. They will not be successful because it will be readily transparent that there is no reduction in gun crime and that Bill C-21 has done nothing to move the needle. But that is what they will try to do. What the government is attempting to do with Bill C-21 is something similar to what another Liberal government tried to do 3 decades ago with a bill called C-68. In the mid-1990s, Bill C-68 established the infamous long gun registry. It was sold as a panacea that would solve many of Canada's problems with gun crime. Like all gun control bills before it, Bill C-68 was supposed to lessen gun crime by imposing yet more controls on lawful firearms owners. The problem was that Bill C-68's objectives proved to be completely unrealistic and unworkable. The long gun registry had been projected to cost just $2 million, but it actually ended up costing taxpayers $2 billion instead. But as Senator Gold always says, the government was serious about fixing this. And the registry itself had absolutely no impact on firearms crime. Because the legislation could not accomplish what the government claimed that it would do, public support for the bill evaporated. I believe the same will happen with Bill C-21. There is simply no chance that Bill C-21 can work as advertised because while the government claims it is addressing handgun crime, the bill actually contains no measures that will reduce the supply of illegal handguns that are being accessed by criminal gangs in Canada. Bill C-21 not only does nothing on illegal guns, but it does also not even reduce the number of legal firearms in circulation in Canada. Instead, the bill merely prohibits the approximately 650,000 Canadians who are legal handgun owners in Canada from selling their guns or buying new ones. This will have no impact on gun crime, but it gratuitously targets those 650,000 Canadians, making them the de facto scapegoats for a bigger societal problem. The government probably believes that targeting those 650,000 Canadians will be more manageable a number than the 2 million plus Canadians who were targeted by Bill C-68 in the 1990s. But in the end, Bill C-21 will be just as ineffective and just as divisive as Bill C-68 was. And in the end, Bill C-21 will meet exactly the same fate. I want to focus the first part of my remarks on explaining the major factor that has contributed to making Bill C-21 as bad as it is. The root of this lies in the total lack of consultation that the government engaged on this bill. When the current minister appeared before a committee on October 23rd, he claimed the following with respect to consultations, and he said, and I quote, "We engaged First Nations, Inuit, and Métis organizations, rural and northern communities, victims group, and with the firearms community and sports persons and sports shooters across Canada to hear their perspectives and to ensure that we respect their traditions and way of life. These consultations have informed our path forward." Yet soon after the minister made that claim, our committee began to hear from its first witnesses. Our very first witnesses were chief firearms officers from Alberta and Saskatchewan. One would think that if the government was drafting serious firearms legislation, the chief firearms officers in the provinces as a group would be ones with whom the government would consult. However, Dr. Terry Bryant, chief firearms officers for Alberta, responded in this way when asked about whether they had been consulted. Dr. Bryant said, and I quote, "I can answer that very quickly and save time. No consultation whatsoever." Again, no consultation whatsoever. Mr. Robert Freeberg, the chief firearms officer for Saskatchewan, said, "Consultation was zero." Not a little bit, zero. The blunt nature of these answers led me to ask many of the other witnesses who appeared before the committee what consultations the government had with them before the bill was introduced. Gilbert White, chairperson for the Recreational Firearm Community of Saskatchewan Wildlife Federation, told us this: the Saskatchewan Wildlife Federation was not consulted. Eric Schroff, executive director of the Yukon Fish and Game Association, stated that his organization received a visit only after the government tabled amendments to the bill late last year. They were not consulted before that. When he appeared, the minister had claimed to us that, "I don't think hunters or sports groups oppose this legislation." That's again a quote from the minister. I asked Mr. Schroff about that specific claim, and he responded that, on the contrary, "I do not know of any sporting organizations that support this legislation." Gilbert White said the same thing, and I quote, "From my perspective, we don't know of any hunters or organizations that support Bill C-21. Where does the minister get off saying these things? Marc Renaud, president of the Federation of Quebec Anglers and Hunters, said, and I quote, "In Quebec, our federation is not aware of any organization that supports this restrictive bill, from our sports shooters to our shooting clubs, our members, or our hunters." I asked Marcel Wilson, founder of the One-on-One movement in Toronto, "Are you aware of anyone within your community with which the government consulted before they introduced this bill?" He responded, "I would have to say no, not one." On November 6, Senator Deacon asked Sandra Honor, chair of the board of the Shooting Federation of Canada, "Were you and your group consulted? Did you have an opportunity for input or speaking?" She responded, I quote, "The Shooting Federation of Canada was not asked to participate in either the committee that discussed Bill C-21, nor did we have letters answered to us after we wrote the minister several times to request. When we then turned our questions to witnesses who appeared from various Indigenous organizations. Remember that the minister had specifically told us that, and I quote, "We engaged with First Nations, Inuit, Métis organizations, and I don't think Indigenous peoples writ at large oppose this bill." But Chief Terry TJ of the Assembly of First Nations told our committee on November 6 that consultation with them was minimal or none at best. I would say not enough, certainly. That is why we passed a resolution last December. Chief Jessica Lazar of the Mohawk Council of Kanawaki was asked whether the government consulted her First Nation before the bill was introduced. She responded, "No, we had one meeting, and that wasn't necessarily an adequate consultation, so I wouldn't consider it consultation whatsoever." Paul Erngott, Vice President of Nunavut, Tungavut, told us on November 8th, and I quote, "Neither the ITK or the NTI has been fully consulted on the language and impacts of the bill." Will David, Director of Legal Affairs of Tapparit Kanatami, told us this. Put simply, there was none. The minister had reached out and offered, and we had reached out and requested, but that consultation never occurred. We're still waiting. Not a single representatives of the Indigenous organizations who appeared before us told us that they had been consulted before Bill C-21 was introduced, despite what the minister claimed, clearly said. Remember, this is the government that pushed for the adoption of the United Nations Declaration on the Rights of Indigenous Peoples. The minister told us at the time that adopting UNDRIP meant that going forward, the government would honor the principle of nothing about us without us. I asked Chief Terry TJ of the FNN what that pledge actually means if on a bill like this there is no consultations before the bill is introduced. The chief responded as follows. Well, clearly, that doesn't meet the standard that we want to adopt, especially with legislation that may have very adverse effects on our Indigenous peoples. Free, prior, and informed consent means that there would be proper consultation with First Nations. I would say even deeper consultations if that had any adverse effects on Indigenous peoples, especially with regard to our inherent rights. Colleagues, I do not see how one can come to any conclusion other than what the minister told us in committee was a complete and total falsehood. I remind senators again what he actually said, and again I quote, "We engaged with First Nations, Inuit, and Métis organizations, rural and northern communities, victims group, and with firearms community and sports persons and sports shooters across Canada to hear their perspectives and to ensure that we respect their traditions and way of life. These consultations have informed our path forward." I would submit on this basis alone, Bill C-21 should be rejected by this chamber. What the minister told us is not true. We need to ask whether there are any consequences when the government lies so blatantly. I certainly believe there should be consequences. But at a minimum, even if some believe that the bill itself should not be rejected for that reason alone, then at least the bill should have been amended to require consultations before it actually comes into force. Consultations are important on any bill dealing with a complex subject matter because it is always outside experts and stakeholders who know more than the government. We propose such a mandatory consultation amendment at committee. But of course, that proposal was rejected by the majority of the government-appointed senators. We then proposed another amendment, that the government at least be required to consult with Indigenous peoples before enacting any regulations that flow from this bill. Such consultations would be required if regulations impacted the Section 35 rights of Indigenous peoples. But that amendment, too, was rejected by the majority of government senators, not only at committee, but also here in chamber in response to the amendment that Senator Boisvenu proposed. The only conclusion that one can draw from this is that not only do the principles of UNDRIP mean nothing for this government, that much is obvious, but in practical terms, they also mean very little for the majority of the government-appointed senators. Senator Lavican-Benson, who repeatedly reminds us that she is from Treaty 6 territory, tried to tell us this at committee, and I quote, "I believe very strongly in meaningful consultation." So do I. With Indigenous organizations. I sponsored the UNDRIP bill that was passed in 2021. Obviously, I fully support the idea of consultation, and the government is getting better at it. I would ask Senator Lavican-Benson, at what point will reality ever catch up with rhetoric? Or is the rhetoric all that really matters? I do want to acknowledge that at least two government-appointed senators did take their roles at our committee seriously. These were Senators Deacon and Anderson, and of course, Senator Richards. They disagreed with some of the amendments proposed, but I believe they did at least consider all the amendments seriously. On this issue of consultation, Senator Anderson in particular made an impassioned plea that future reviews should not take place behind closed doors. She was honest about what such cosmetic reviews had meant in the North in the past. She said, and I quote, "In regard to the review, I'm not confident of a review. We have reviews constantly in the North. Half the time, maybe more than half, we never hear back about those reviews. People don't even know there are reviews going on. That's problematic. We already know it's an issue. We have a responsibility as legislators to address that issue. We have the authority to do that. To fail to do that is to fail in the aspects of reconciliation. Section 35 Charter rights. It's unconscionable. I do not think an observation is sufficient. I think it's insufficient. I've been here for 5 years. There have been a lot of observations in regard to Indigenous issues. I can't honestly tell you one that I've ever seen acted upon. And that, I think, is what also concerns the many stakeholders who appeared before our committee. For all Indigenous hunting and sporting organizations who appeared before our committee, it is the government's track record on consultations which suggests they will also not be listened to in the regulatory process. The government has been very clear in stating that there will be regulatory processes arriving from this bill. That much we know. In the House of Commons late last year, the government was prevented from pursuing a broader firearms prohibition that would have specifically targeted hunters, including Indigenous hunters. This means that there is a serious potential for regulations that will be drafted behind closed doors that will target hunters. A number of witnesses expressed their concerns about this. Nathan Obed, the president of Inuit Tapiriit Kanatami, told our committee, "We have seen no government-wide implementation of the structures that we have tried to build with the Government of Canada on systematically upholding our rights and allowing for our participation in things such as legislative processes like regulations. Therefore, we have very little confidence that we would participate and be able to co-develop those regulations." Similarly, Tom Erngut, Vice President of Nunavut Tungavut, told us, "I really don't have a lot of confidence if it's passed very quickly as we've seen in the past. We need to be consulted on this Firearms Act just so that people are aware and can voice their concerns."
Sorry to interrupt you, Senator Plett, but honorable senators, it is now 6 o'clock, and pursuant to Rule 3-31, I am obliged to leave the chair until 8 o'clock when we resume, unless it is your wish, honorable senators, to not see the clock. Is it agreed to not see the clock? Honorable senators, leave is not granted. The sitting is therefore suspended, and I will leave the chair until 8 p.m. Sitting has resumed. Senator Plett.
Thank you, Speaker. So I'm not entirely sure where I left off.
You have unlimited time, so you're not in a...
So I could start over again?
You should start over, just to be clear.
All right. I rise today to speak to Bill C-21. Colleagues, I think this is where I left off. Nathan Obed, the president of Inuit Tapirut Kanatami, told our committee, "We have seen no government-wide implementation of the structures that we have tried to build with the Government of Canada on systematically upholding our rights and allowing for our participation in things such as legislative processes like regulations. Therefore, we have very little confidence that we would participate and be able to co-develop these regulations." Similarly, Paul Erngott, Vice President, Nunavut, Tungavik, told us, "I really don't have a lot of confidence if it's passed very quickly. As we've seen in the past, we need to be consulted on this Firearms Act, just so that people are aware and can voice their concerns." Chief Jessica Lazar of the Mohawk Council of Kanawaki said, "We also have concerns about meaningful consultation for regulations because it will deeply affect how our people can carry themselves and carry their firearms. So we would like to have a closer look at what that looks like." When this was discussed in committee, some senators said they wanted to get a better idea of what future consultations should look like. For instance, Senator Cardozo asked Chief Lazar, "The way I understand it is that if this bill passes, the department in charge would then be in charge of developing the regulations. We could consider this, as a Senate committee is, to be fairly specific, in terms of what we suggest to them about how to go about these consultations, recognizing that they didn't take place earlier on when the government was developing the bill. Would that be the way to go?" Chief Lazar responded, "Yes, the way to go would be to set up an initial meeting that would have to consist of a plan for meaningful engagement. You need to have a plan to ensure that you cover all sectors and all the needs of both parties. In order to do that, we need to have that initial meeting." Responding to all this witness testimony, an amendment was then proposed at our committee to ensure that the regulatory process on firearms be informed by consultations with Indigenous peoples. But that amendment was defeated by the majority of the government senators, including, of course, by Senator Cardozo as well. So the regulatory process remains entirely in the hands of the government to do with it what it wants. It has failed to engage in any consultations to date. And unfortunately, that is what we can also expect going forward. I now want to turn my remarks to addressing what some of the outcomes are when a government does not consult. The main outcome is that it will likely produce a very bad bill. In C-21, we can see this outcome in two areas in particular, namely, in the proposed ban on the purchase and sale of legal handguns, and in the expanded definition of what constitutes a prohibited firearm. Turning first to the ban on the purchase and sale of legal guns. This component of the bill is the most gratuitous element in the bill because it targets about 6 750,000 law-abiding Canadians for essentially no supportable reason. The firearms that have been used by licensed sport shooters and collectors for many decades and are held under very strict conditions in Canada. We need to remind ourselves, colleagues, about the very specific restrictions that already apply to all restricted firearms owners in Canada. They must all pass the restricted firearms training course, go through and remain subject to continuous police background checks. Only, and before the current freeze, acquire handguns for either sport shooting or collecting. Only transport them to an approved shooting range. Always store and transport their handguns double locked and only transport them as approved by the CFO of their province. And individually register all their restricted firearms. I do not believe that most Canadians or even senators are actually aware of all the restrictions that already apply to restricted license holders. But by framing the issue as simply as possible and by presenting the ban on the purchase and the sale of legal handguns as a simple option, the government hopes its simplistic messaging will sell to what they hope is an uninformed public. If we are going to be frank, Senator Dasko adopted a similar approach in a poll she commissioned a few weeks ago. Her poll asked whether respondents supported freezing the sale and transport and importation of handguns. Senator Dasko proclaimed that 73% of Canadians either supported or somewhat supported this government objective. But what context was provided in that poll about Canada's already existing handgun laws? Were the respondents told that it is only licensed sport shooters and collectors who can legally own handguns in Canada? Were all the existing legal restrictions clearly explained to respondents? When a poll asks a general question but provides no context, the result is predetermined. What Canadians will find out in the years ahead is that C-21's ban on the purchase and the sale of legal, already tightly controlled handguns will not make Canadians any safer. As nearly every witness who appeared before our committee pointed out, the vast majority of handguns being used in crime in Canada are being smuggled into this country. Professor Noah Schwartz testified before the committee and pointed out that in Montreal, 95% of handguns used were illegal, and 79% of all traced handguns in Ontario were foreign-sourced, largely coming from the United States. Professor Christian Lupert of the Royal Military College of Canada told our committee, "The data is unequivocal. Well over 90% of firearms seized in the commission of a crime or that are possessed unlawfully in Canada have been smuggled by organized crime from the United States. Show me the data that supports this bill. There is none." Marshal Wilson, who was formerly involved in criminal activity in the City of Toronto at a senior level, confirmed at our committee that gang members are only interested in illegal firearms that are untraceable and that the primary source of such firearms is the United States. In essence, the reality is this: banning the sale and purchase of legal handguns will not reduce firearms in circulation because the bill provides that such firearms will only be taken from the estates of such individuals without any compensation after their death. This measure will, for instance, have no impact on suicides because you are not actually reducing legal handguns in circulation. Furthermore, a fact that government senators often miss: every holder of a restricted firearms license also automatically holds a non-restricted firearms license for long guns. That means that they can possess all long guns in addition to their handguns. So how does limiting what restricted license holders can do with only one class of firearm impact any of the other firearms that these individuals already legally possess? The truth, of course, is it doesn't. Therefore, there can be no impact on the problem of suicides by firearm, nor will there be any material impact on the larger problem of stolen firearms. A number of police officers, both serving and retired, testified before a committee on this very specific point. The officers who testified were unanimous that Bill C-21 would not impact the problem of handgun crime in Canada. Mr. Andre Chalina, formerly a detective sergeant with the Montreal Police, stated that there is no link between the gang violence in Montreal and firearms illegally held by sport shooters. His colleague, Stéphane Wall, also formerly of the Montreal, made the exact same point. Even those senior police officers who gave the government the benefit of the doubt on Bill C-21 were nevertheless quite clear in noting their skepticism about the bill's effectiveness. Bill 40 of the Canadian Association of Chiefs of Police told our committee, and I quote, "Regarding the issue of smuggling and trafficking, the CACP continues to maintain that restricting lawful firearms ownership will not meaningfully address the issue of illegal firearms obtained from the United States." Similarly, the Deputy Chief Fiona Wilson of the Vancouver Police told the committee that, "To date in Vancouver, we have had 22 shots fired incidents in 2023, resulting in 3 homicides and 16 people wounded. 15 of the 21 incidents have confirmed or suspected links to gangs." She also said that without exception, firearms crime does not emanate from licensed gun owners. And what of the government's current efforts to tackle the real problem of firearms smuggling? Mark Weber, National President, Customs and Immigration Union, told our committee that much of what the government does at our border is actually only security theater, in his words. While Aaron McCrory, Vice President, Intelligence and Enforcement Branch, Canada Border Services Agency, told our committee that the results that CBSA has achieved at the border in stopping firearms smuggling are, quote, "a great success, and we're very proud of it." Mark Weber strongly rejected this claim when he testified. Mr. Weber told our committee this: "The agency's ability to stem the flow of illegal firearms has not improved a bit over the past 2 years. Border officers still lack the ability to act between ports of entry, making it harder to address problematic situations in a timely fashion. Tools such as mobile X-rays that could help in intercepting illegal contraband, including dangerous firearms, frequently break down. There is still an almost 0% chance that any illegal weapon entering the country through rail would ever be found. Any thinking person would be legitimately concerned about this imbalance in the current bill." We were told by a number of witnesses that the government's measure to increase the maximum penalty for firearms trafficking from 10 to 14 years will have no impact on trafficking, because the current maximum of 10 years is never imposed by our courts. I noted this fact during my second reading remarks, and unfortunately, That conclusion was confirmed by witness testimony. Senator Yussuff asked officials from the Department of Justice what the average sentence was for firearms trafficking. Mr. Matthew Taylor, General Counsel and Director of Criminal Law Policy Section of Justice Canada, responded by noting that in 2019-20, there was one conviction, resulting in imprisonment of more than 2 years. In 2018, sentencing was from as low as 3 to 6 months to more than 2 years. So the sentences are what they are. The government is evidently fine with that result, since government senators rejected all amendments that were proposed to restore some minimum sentencing for firearms offenses that were repealed under Bill C-5. Senators should understand what that means. It means that people in our most vulnerable communities will continue to suffer the most from gun crime. This is what Mr. Marshall Wilson told our committee related to the claim Bill C-21 will tackle gun crime. He said, "Please stop exploiting people who have already been through enough for a political agenda. We know better, we want better, we deserve better." I can assure senators opposite of this, Canadians either know or will soon find out that Bill C-21 is a smokescreen. It is a smokescreen that makes legal gun owners scapegoats. It will do nothing to reduce real gun crime. In particular, it does nothing to help people in our most vulnerable communities. And that will become very evident as gun and gang crimes continue to rise. The final element in this bill that I wish to address is the expanded definition of prohibited firearm that the bill contains. Before I discuss this specific provision, I think we need to remember that certain firearms have been prohibited for civilian use in Canada for a very long time. These include fully automatic firearms. They include semi-automatic firearms, semi-automatic center firearms that shoot more than 5 rounds. They include sawed-off shotguns. They include short barrel pistols. They include various other firearms that have from time to time been selected for prohibition for one reason or another. But now, in Bill C-21 and building on the order in council that the government enacted in 2020, the definition of prohibited firearm is to be further expanded in a largely meaningless matter. In the bill, the government expands the definition of a prohibited firearm to include a firearm that incorporates all of the following criteria. It is not a handgun. It discharges center fire ammunition in a semi-automatic manner. It was originally designed with a detachable cartridge magazine with a capacity of 6 cartridges or more. And it is designed or manufactured on or after the day of which this paragraph comes into force. All of these criteria must apply for the firearm in question to be prohibited under the new definition. When Senator Yussuff spoke to the bill at third reading, he claimed that this bill has nothing to do with long guns. Well, I am sorry, but this clause in the bill, which amends subsection 84(1) of the Act, is only about long guns. In fact, the clause specifically excludes handguns. As we heard from witnesses, there are numerous problems with this proposed definition. What the government is attempting to define is an assault-style firearm for which there actually is no definition. I am sure that if many Canadians were asked what that term meant, they would say it means a firearm capable of being fired in a fully automatic manner. Indeed, if we think of any military rifle in service today, That is what such a rifle would be capable of. But as I said, such rifles have been legally prohibited for civilian use in Canada for decades. So, instead, the government now proposes to expand the prospective definition to also prohibit firearms simply because they happen to discharge ammunition in a semi-automatic manner. But it will only define such firearms as prohibited if they are manufactured after the date on which the Act comes into force. This means that exactly the same firearm will either be prohibited or legal simply based on the date of manufacture. This is akin to saying the same make of a car manufactured is either prohibited or legal based on the date that it was manufactured. It literally, colleagues, makes no sense. Theoretically, this provision could impact well over 1 million hunting firearms in Canada. Firearms that are actually classified as non-restricted under current Canadian law and which have been assessed as being entirely appropriate for hunting purposes. But it will not apply in that manner because all of the semi-automatic firearms already in Canada are exempt from the provision. So too is any semi-automatic rifle that might be imported, as long as it was manufactured before the date on which the provision comes into force. Senators should understand what this means. This means that literally tens of millions of semi-automatic firearms are eligible for import into Canada, simply based on the date that they were made. I really need to ask, how does this enhance public safety? Of course, the answer is that it has absolutely no impact on public safety. In his third reading remarks, Senator Yussuff claimed that the fact that the measure is ineffective means that long guns are not impacted by the bill. If that is the case, then why have the provision in the bill at all? In fact, an amendment was proposed at committee for the section concerned to be deleted from the bill. But again, government senators, including Senator Yussuff, voted against that amendment. Senator Yussuff cannot have it both ways. He cannot say that nothing in the bill impacts long gun owners and then vote against the amendment deleting the clause which references long guns. In this regard, we have to be aware of what the government is signaling about what it intends to do. It may be signaling that it will try to do through regulation what it failed to do through legislation last year. Because so many semi-automatic firearms are non-restricted and used for hunting, when the government attempted to enact a wide prohibition last year, hunters across the country, including, of course, Indigenous hunters, understandably reacted very negatively. They did so because the broad prohibition that was being proposed had no credible justification. I do think that stakeholders are right to be very concerned about the government's future intent. It seems highly probable that the government still has the aspiration to do through the back door what it tried and failed to do through the front door. Many witnesses, particularly Indigenous hunters, share that concern. They are rightly worried about the government's long-term intent. They are particularly concerned about the arbitrary decisions which will take some semi-automatic firearms away from hunters, but leave others in their possession. As Paul Ehrengold, Vice President Nunavut Tungavik, told our community, in his view, the proposed definition of assault-style firearm is problematic, and I quote, "The definition is overly broad and covers many semi-automatic rifles used for hunting or defense against predators in Nunavut. Inuit have treaty rights to hunt under the Nunavut Agreement. Hunting is a necessity for survival for a lot of Inuit in Nunavut. Semi-automatic rifles are effective and necessary as a humane method to quickly dispatch animals and as a defense against polar bears, grizzly bears, and wolves. Inuit hunters are taught to prevent dangerous encounters and to scare away these predators. But that is not enough. It could mean life or death when one or more aggressive bears are breaking into your cabin or tent. You would need to be able to scare them away quickly, and you might not have the time to reload. If this bill is passed with the ban on semi-automatic firearms, we will have to shoot to kill, resulting in increased fatalities of wildlife. There are some provisions in the Act that we are not opposed to, but the broad definition of assault rifles is quite concerning to us. Colleagues, take note, this is a life and death situation for people up north. They are protecting their lives, their families' lives, and wildlife. For those hunters who depend on their firearms for subsistence, this is understandably very worrying. In response to this, an amendment was proposed at committee to ensure transparency in the envisioned future regulatory process. Hunters deserve that sort of transparency, and in particular, Indigenous people who depend on subsistence hunting and whose rights are impacted and should be consulted. That is what the amendment proposed, colleagues. But unfortunately, as all the other amendments, the amendment was rejected by the government majority. Now what Indigenous and other hunters fear is that the government will do what it has already done in 2020, Order in Council, to arbitrarily select certain semi-automatic firearms for prohibition. We need to be clear. The measure that the government enacted in 2020 had absolutely no public safety benefit. In fact, it is one of the dumbest measures ever enacted by a Canadian government. This measure selected some semi-automatic long guns for prohibition, largely for their look, while leaving all others in legal circulation. In other words, one semi-automatic long gun is prohibited, but another semi-automatic long gun that may shoot precisely the same ammunition remains legal. Moreover, since the government says it will pay compensation to those firearms owners whose firearms have been arbitrarily prohibited, nothing prevents these firearm owners from simply using that money to purchase another semi-automatic firearm that may shoot precisely the same ammunition as the firearm that has been prohibited. This is liberal thinking to the nth degree. The Parliamentary Budget Officer has estimated that this idiotic compensation program will cost taxpayers at least $750 million.
And more.
But what's a few dollars among friends, is what the Liberals say. In essence, taxpayers will be paying firearms owners to hand in certain of their semi-automatic long guns so that they can use that money to go out and buy another semi-automatic long gun. Only this Liberal NDP government could come up with a program that is so utterly pointless, but still ends up costing taxpayers at least $750 million, as Senator Bobineau said, and probably more. Dr. Kaylin Langsman, Assistant Clinical Professor of McMaster University, testified before our committee, and he pointedly stated, "The likely billions of dollars spent to confiscate firearms from legal firearms owners would probably be better spent on youth diversion and gang reduction programs, as well as programs in terms of suicide reduction and women's programs for leaving homes at risk. I see people coming in with suicidal ideation from issues they have in terms of depression, and it's extremely difficult to get them help. We look at wait times of over 6 months for some people. We have a shortage of physicians who are working in this area. Not only will these confiscation measures have no public safety benefit, they will literally rob frontline police and other workers of very scarce resources. How is this sort of public policy making acceptable? How can the Senate, which is supposed to exercise sober second thought, possibly sign off on a bill that confirms an order in council that is so stupid? Just to be clear, I am not against paying compensation given circumstances. Firearms owners acquired their firearms legally and in good faith, and they should be compensated when the government arbitrarily decides to prohibit their property and steal their property from them. But the policy itself makes no sense from a public policy perspective. In fact, what is being done is so wasteful and so pointless that it almost staggers the imagination. All of this simply to provide the illusion that the government is doing something. They are taking everything seriously. And that's the answer. We'll be given a question period tomorrow. We take it seriously. In my remarks up to this point, I have discussed what the bill fails to do despite the government's claims. Now I want to focus on just one of the bill's most negative impacts, that being its impact on licensed sport shooters and collectors. These law-abiding Canadians may be modestly impacted, or they may be very badly impacted. Let me begin with the collectors of handguns, including many who collect antique firearms. Tony Bernardo, Executive Director of the Canadian Shooting Sports Association, told our committee this: there are a number of large collections. There are a number of small collections. Some of the collections might be only 2 or 3 handguns, and those collections would be worth, for example, $2,000 or $3,000. But the larger collections could be worth well into the hundreds of thousands of dollars. I would guesstimate that the overall value of handguns would be in the hundreds of millions of dollars across the entire country. So there is no question that collectors, many of whom are historical collectors, are very impacted. They can no longer sell or buy legal handguns, and their collections are forfeited to the state when they die. Contrast this obvious impact with what the minister told us, and again I quote: the premise that this affects law-abiding gun owners who pursue sports activities such as hunting or sport shooting is a phrase that is often used. We have been explicit and careful to ensure that these measures do not target those people. They are not targeted or affected or included in these measures. It's the minister. With a straight face, he told us that. With a straight face. Once again, the minister's statement simply has no connection to reality. None. Some senators are cavalier about this outcome. Senator Couture shrugged his shoulders in committee and simply said that Canadians do not have a constitutional right to own firearms. He offered no criticism of the fact that the governments in this country have for decades asked sport shooters to play by the rules and to abide by very strict conditions related to ownership of handguns. Those legal firearm owners have always abided by the rules. But now the government has arbitrarily decided to change those rules, and it offers absolutely nothing in terms of an apology or compensation. At least our Prime Minister, who is so good at apologizing for everything everybody in this country has done, should at least apologize for this. Senator Couture can be cavalier about that sort of betrayal, but in my view it is completely unacceptable. Ironically, it will also ensure that no restricted gun owner will hand over their firearms. Those guns will remain in private hands, something which the government purports to be so worried about. How exactly does that enhance public safety? The truth, of course, colleagues, is it doesn't. Freezing someone's collection of antique or other historic pistols is a ridiculous measure. Even for senators on the government side, that should be more than obvious. Let me now turn to the impact that this bill will have on specific shooting sports. The truth is that shooting sports in Canada will be destroyed by this bill. They will be eliminated. The government has claimed that it is protecting Olympic and para-Olympic level competition in all of this. Again, the minister, before our committee, said, we're not affecting the ability of these elite athletes to access firearms they need for their sporting competitions. It's not only the persons who go to these international competitions representing Canada, it's those who are training and getting ready to one day hopefully have the opportunity to do that. But of course, none of that is accurate. It isn't even accurate today, and the bill is not enforced yet. In this regard, Senator Deacon asked the Chief Firearms Officer, who appeared before a committee, how they have navigated the prohibition on the purchase of handguns by Olympic athletes since the government imposed its order in council last year. Dr. Terry Bryant, Chief Firearms Officer of Alberta, told us, we have not been successful in securing an exemption for Olympic-level shooters, even once. I am unaware of anyone, anywhere, who has. Not even once. I am unaware of anyone, anywhere, who has. Again, remember that the minister told us the Olympic-level competitors are specifically exempted and there is no intent to impact them. That, colleagues, obviously is completely false. We were told by a previous speaker not to call a duck at times, and I'm paraphrasing, but I am not allowed to call the minister what he did here. This is false, colleagues. He is not telling us the truth. Now the minister is again promising that going forward he will consult, because he's serious about it. He will consult about how to actually exempt Olympic and Paralympic shooters from the effects of this bill. He wrote a letter to this effect, which Senator Yussuff has proudly quoted. The minister says, I want to assure the committee that consultations will take place so to clearly establish the process for elite sport shooter exemption. How do you square that? Will take place. Earlier he said they have taken place. With all due respect, given the minister's track record, this statement means absolutely nothing and has zero credibility. And particularly, it means nothing because below the Olympic level, the government makes no pretense. All of these other shooting sports are to be annihilated. Since nobody starts competition at the Olympic level, this means that Olympic quality competitors as well will soon not be fielded by Canada at all, because nobody begins at this level. Colleagues, it may come as a surprise to you, but Wayne Gretzky didn't start playing hockey in the NHL. He actually started on an ice rink in his backyard when he was 3 years old. He practiced. He bought hockey sticks. They weren't disallowed. They weren't illegal. But here our sports shooters are supposed to start in the Olympics. Robert Freeberg is the Chief Firearms Officer for Saskatchewan, and he was once an Olympic-level competitor. This is what he told our committee. I was an Olympic target shooter, but I didn't start there. Surprise, surprise. I started in another sport, shooting, and then I developed some skills. And they said, hey, you've got an ability to do this. And I slowly started to move up into shooting in the Olympic sports. And eventually, even though as I aged, my eyes went, I could feel it. I went off to shoot in other sports because I wasn't able to compete in the Olympic realm anymore. But at least I had another place to go and enjoy my sport. That's gone. There is no way to feed in the Olympic system, and there is no way for us right now, currently, with these regulations, They are just refusing to pass the application. So this will not only kill all shooting sports, it will also leave former Olympic athletes with an unclear path of even recouping their investments in their own sport. These athletes will have no ability to mentor new athletes because there just won't be any. Linda Geico is a civil engineer and an Olympian, testified before our committee, and she was very clear on that point. And she said, and I quote, "Target shooting is one of the most inclusive, lifelong sports in the world, and one Canadians should consider valuable. Target shooting sports provide a level playing field that no other sport really provides. All people, all body shapes, all genders, able-bodied, otherwise, it doesn't matter. We can all compete shoulder to shoulder against each other on a level playing field." That, colleagues, is completely gone, out of the window. Colleagues, I've been here since 2009. I have seen many bills go through this chamber, and I have seen some bad bills before. But frankly, there is no bill that is as absurd as this bill. And in this regard, I want to quote from what Professor Christian Lupert told our committee based on his analysis. "Instead of being honest with Canadians and devising constructive policies that will actually curb the northbound torrent of crime guns from the United States, this bill constructs a false narrative against 4 million lawful, licensed, background-checked firearms owners. This legislation is a cynical ploy to polarize Canadian society by leveraging firearms as a wedge issue ahead of the next federal election." That is not Pierre Poilievre that said that, colleagues. In over 20 years of studying public safety and national security across democratic countries, I have never seen a bill with this great a disconnect between its supposed means and ends. Any parliamentarian who votes in favor of this bill is going on record as disdaining evidence, supporting derision, fanning polarization, encouraging disinformation. Disinformation, Senator Gold, you're so quick with using that word every time we say something, and wasting scarce public resources on policy measures that miss their intended targets. I do not think there could be a more succinct or accurate summary of the bill that we have before us. I just want to add an additional comment in relation to this. I understand the sentiments that underscore this bill. I understand the sentiments of those who are victims of crime, and particularly those who are victims of gun violence. I can assure you there is no senator on the committee who did not have the most profound sympathy for Samantha Price and all the other victims of senseless gun violence who appeared before our committee. But we need solutions that actually work. And as I have said before, Conservatives support reasonable gun control. We support licensing. We support safe storage laws. We support mandatory firearms training. We support thorough police background checks. But colleagues, what we are doing is a disservice to Canadians if we just give in and pretend that a bill like this will seriously address the problem of gun violence in any real way. We are also doing an extreme disservice to the victims of gun violence, who will be the first to realize that. As it turns out, Bill C-21 means nothing in terms of addressing such violence. I am now thinking of the appearance of Mr. Bolfelja Benadallah, the co-founder and spokesperson for the Islamic Cultural Center of Quebec City. We know about the terrible massacre that occurred there. 6 people were murdered in a place of worship. Others seriously injured. I cannot imagine the horror suffered by the families that face this unspeakable crime, a crime of this nature. If we are considering root causes, what we are dealing with in an event like that is an almost unimaginable amount of hate. Hate of that nature is part and parcel of most of the mass shootings that we see. But how does one realistically ensure that such events can never happen? I believe it is virtually impossible to ensure such an outcome, given what history teaches us about human beings, what we are capable at our very worst. A simplistic solution is to say that more gun control is the answer. The government chose that approach when it randomly prohibited certain semi-automatic firearms, but not others. As Senator Yussuff himself has noted, there are at least 12 million guns in Canada. Even after Bill C-21 is enacted, there will still be at least 12 million guns in Canada. We have witnessed other mass killings where the weapon used was an automobile. In Toronto in 2018, a van was used to kill 11 people and injure many more. Without transforming the human soul, we will not stop these sorts of events. What also concerns me in relation to the Quebec tragedy is the message we send as a society and how we responded to this attack. Initially, the perpetrator of this crime was sentenced to life in prison with no chance of parole in 40 years. To be frank, in my opinion, that was a sentence that was too light, given the terrible crime that this individual committed. Yet, for our Supreme Court justices, the sentence was too harsh. So they reduced that sentence to ensure that the perpetrator would be eligible for parole one day so he could commit this crime again. Quite frankly, this is an outrageous decision which the Government of Canada simply accepted, even though it had the legislative options to say to the court, no, we do not agree with your decision and we will reverse it. As a society, we cannot just roll over and accept decisions that fail to hold perpetrators of the worst crimes morally responsible. But that is what this government does, time and time again. It is simply wrong to instead enact gun control laws that we know will not work. It is particularly very wrong for the government to target 650,000 Canadians and make them scapegoats for what is wrong with society. That is just simply wrong. But that is what we have in Bill C-21. This is a bill designed in Ottawa by people who are looking for simplistic talking points and who, quite frankly, do not understand other parts of the country. Does it remind you of another bill that we dealt with earlier today? We heard that complaint from many of our witnesses. We heard it from Indigenous people, including our Inuit witnesses, who spoke about the fact that in the North they don't even have their own chief firearms officers. Instead, the chief firearms officer for the North resides in southern Canada. People in Toronto and Montreal know what's best for the farmers in Saskatchewan. That is a large part of the problem with this entire bill. It is a bill designed in Ottawa by a central Canadian elite that simply does not understand, or quite frankly care to understand, other parts and peoples of Canada. In that sense, Bill C-21 is just like Bill C-68 3 decades ago. And it will fail for the very same reasons. Make no mistake, colleagues, this bill will be reversed. That's the silver lining here. This bill will be reversed. That is the inevitable outcome of what we are doing today. But in the years in between, all we will have accomplished is to sow yet more division in our wonderful country. Now, I have been accused of delaying this bill. The minister has said, and other government members in the other place have said as well, that it is all part and parcel of this government's wedge politics. That is all part and parcel of this government's wedge politics. I was told I was delaying this bill before it was ever introduced in this chamber. Before it ever even got here, I was already, the tweets were out there by the government. Senator Plett is stalling Bill C-21. But Bill C-21, even though it is one of the dumbest bills ever enacted by the current government, has progressed through the Senate.
And they have many.
In accordance, and they have many, and they have many. The sad part is that they have some time left to introduce more. But the bill has progressed through the Senate in accordance with the schedule negotiated between the Liberal government, the leader of the government in the Senate, and the leader of the Conservative opposition. From day one to now. All the meetings of the committee were scheduled by consensus between all members of the committee. And I quite frankly want to thank Senator Tony Dean for the collaborative way in which he dealt with members of our party in scheduling these meetings, giving us the witnesses that we asked for. The Conservative opposition agreed to have committee members during the regular Monday time slots. We agreed to sitting during the Mondays after a break week. We agreed to meeting on Wednesdays during the Veteran Affairs Committee time slot, and also on extra days. The bill finished clause by clause on December 4th, exactly as we had agreed. Yet the political messaging by this government remained the same. The Conservatives are delaying the bill. For the record, I told Senator Gold last week that I wanted to speak today. I wanted to speak first. I'm the critic of this bill. Normally, we have a policy where the critic speaks last. I asked to speak first. Why? Because I'm delaying the bill? That doesn't make a lot of sense. I will admit the official opposition has been looking for a way to defeat this bill. Short of divine intervention, I don't think that will happen. But most of the witnesses who appeared before our committee either asked us to kill this bill or at least make major amendments. Most of our witnesses. Unfortunately, we failed them. We tried, but we had a very strong government contingent who said, we're putting this through. Whether it's a good bill or not is really irrelevant. It sends a good message, and we're going to put it through. But the reason we tried our best to do that is because this bill is not good for Canada. And Conservatives care about Canada. We care about our country. And it is not the end of anything. It is merely the beginning of what will be a regrettable requirement now to reverse extremely bad legislation. And we wanted to take every possible step to avoid such an outcome. But that is what this current government ultimately wants, and that is the outcome it has. In conclusion, and I know you've waited for those words for a long time. Now, some people in conclusion, that only means that's the last 20 minutes. I want to come back and focus on just one of the many problems of this bill. Just one. That is the matter of the impact that this bill will have on the entire range of shooting sports in Canada. It will not only kill shooting sports in Canada, it will also close civilian ranges that so many of our police services depend on in order to maintain their skill levels. Again, Senator Deacon. Senator Deacon is one of those Trudeau appointees that actually thinks for herself and has some good ideas. And this was one of them. She proposed an amendment in committee that was rejected by the government majority, but I believe we must reconsider now. I really think this needs to be reconsidered. I know Senator Yussuff thinks that once it's dead, it should be dead, unless it's something that he doesn't support. Then, of course, we make exception. Now, that amendment would ensure that any shooting discipline be recognized as a legitimate for the purpose of an individual to purchase or sell handguns relevant to that discipline. Our committee heard considerable testimony on this issue. I have already referenced what Olympic athlete Linda Keiko told our committee. I also quoted what Mr. Robert Freeberg, Chief Firearms Officer for Saskatchewan, told our committee on the same issue. And I wish to have one more quote here, what James Smith, President of National Range Officers Institute of the International Practical Shooting Confederation, told our committee. Even though Bill C-21 is not an outright handgun ban, it will result in a slow demise for our sport in Canada. Having no athletes introduced to replace the existing competitors and being unable to replace equipment as it wears out will result in the end of our sport over time. It will close the ranges for police officers and other agencies that use our ranges for training and result in no shooting for Olympics. Nowhere in there, colleagues, did he say might. He said it will. The amendment originally proposed by Senator Deacon seeks to at least partially address a major flaw in this bill, in that it will recognize all shooting disciplines. It requires that the handgun in question is appropriate and necessary for participating in that discipline. Some may argue that this amendment would restore the status quo when it comes to handgun purchases. Unfortunately, that is not the case. All this amendment would do is recognize more shooting disciplines under the auspices of this bill. It would require that in order to be involved in any shooting discipline, the individual would have to be a member of a club that offers such a discipline. I would just repeat what witnesses have said, that unless this bill recognizes and protects other shooting disciplines that provide the shooters, who may then be good enough to feed into the Olympic shooting, there is then absolutely no point in the Olympic level exemption that is already in the bill. Colleagues, these are the words you've all been waiting to hear for the last hour. And so I therefore ask you to support what I am going to propose. And I therefore move that Bill C-21 not now be read a third time, but that be thrown in the garbage. Actually, that Bill C-21 not now be read a third time, but that it be amended in Clause 43 on page 49 by replacing lines 27 to 34 with the following. 1, that they are participating in a handgun shooting discipline. 2, the disciplines in which they participate. And 3, that the handgun in question is appropriate and necessary for participating in those disciplines. Thank you, colleagues.
In amendment, it was moved by the Honourable Senator Plett, seconded by the Honourable Senator Martin, that Bill C-22 be not read a third time, that it be amended in Clause 43 on page 49 by replacing lines 27 to 34 with the following. I, that they are participating in a handgun shooting discipline. 2I, the disciplines in which they participate, and may I dispense? Yes. On debate, Senator Deacon, Ontario.
Thank you very much. I rise briefly to speak to my colleague Senator Plett's amendment. I tabled a similar or same amendment at clause by clause, and I deeply commend Senator Plett for his genuine concern for our athletes. But in the interest of thinking for myself, I have continued to think and think more and act following our final committee meeting a few weeks ago, and act I did. I share the concerns, obviously, of Senator Plett. I have worked firsthand with many high-performance shooters and witnessed the challenges they have in moving their competition gear at the best of times. Moving those guns around the world, it's a very, very big challenge. In committee, we heard from, and you heard part of it already today, from two chief firearms officers and athletes concerned that handgun shooting in Canadian sport disciplines could completely disappear as a result of this legislation. I, of course, was very sympathetic to this, which is why I tried to amend this at committee. And it was defeated. And though it was defeated, I do appreciate the degree and due attention this was given at committee. I have since heard from the Minister's office who acknowledged my concerns, which I appreciated. It is not their intention to take away shooting sports in this country for young people, for beginners, or for older people. Our committee also received, as you heard recently, correspondence from the Minister LeBlanc reasserting this commitment in paragraph 3 and 4 of his letter. They are concerned with finding a balance between allowing legitimate shooting sports and competition while also not opening up the back door to handgun ownership. And I appreciate that as well. It's something that they must finely tune in the regulations, and I think I at least need to let them keep true to their word. We've already seen immediate action regarding chief firearms officers in the North, action which came about because of our committee work, not because the bill was passed or approved, but because of the work at committee. So I hope and choose to believe they will follow through on their commitments, as per this letter, when it comes to shooting sports as well. On behalf of Canadians, I have promised sport shooters that I will keep the pedal to the metal on this. So today, I am comfortable with that, leaving the bill as it is in this regard. Thank you.
Are senators ready for the question? Is it your pleasure, honourable senators, to adopt the motion in amendment? All those in favour of the motion will please say yea. Yay. Those opposed to the motion will please say nay. Nay. I think the nays have it. I see two senators rising. You have an agreement on the bill. Pursuant to Rule 9-10(1) and the order adopted on September 21st, 2022, the vote is deferred to 4:15 p.m. tomorrow, with the bells to ring at 4 p.m. Senator Gold.
Thank you, Your Honour. Honourable Senators, I wish to advise the Senate that I have been unable to reach an agreement with the representatives of the recognized parties to allocate time for the debate at third reading stage of Bill C-21, an act to amend certain acts and to make certain to make certain consequential amendments to firearms. Therefore, I give notice that at the next sitting of the Senate, I will move that, pursuant to Rule 7-2, not more than a further 6 hours of debate be allocated at third reading stage of Bill C-21, an act to amend certain acts and to make certain consequential amendments firearms.
And how many times did